Uh, Good morning, Professor Ken Satoh, Dean, faculty members, and engineering students. Welcome to a special lecture at Faculty of Engineering, Yon res won University. Today we have a very special guest speaker, Professor Ken Satoh. He is a professor from National Institute of Informatics, called NII, in Japan. He has been working on logical foundations of AI for 30 years. He has started to apply his foundations to AI and law since 2009. He is now working on various topics in AI and law, including to implementation of Japanese civil code. Today, Professor Ken Satoh will give a special lecture on the topic, the current trend of applications in AI and law. Before we start, may I have an honor of Associate Professor Suchat Yamen, Dean of Faculty of Engineering, Yon res won University, to give an opening speech on this occasion.
Good morning, ladies and gentlemen. It is a great pleasure to be here and to welcome you all to a special seminar on the topic, the current trend of applications in AI and law. Thank you for giving me the opportunity to give opening address. Let me also express my thanks to a very special guest speaker, Professor Ken Satoh. Professor Ken Satoh is a professor from National Institute of Informatics in Japan. He has been working on logical foundations of AI for 30 years, and he has started to apply his foundations to the AI and law since 2009. Today, he is working on various topics in AI and law, including the implementation of Japanese civil code. This seminar is the great opportunity for our engineering students, lecturers, researchers, faculty members, and other people who are interested in the applications in AI and law. On behalf of Faculty of Engineering, Yon res won University, I would like to thank Professor Ken Satoh for sharing his knowledge to us here today. I hope that we might have an academic and research collaboration together in the near future also. Ladies and gentlemen, thank you for your time. I wish you all a successful seminar. At this auspicious moment, may I officially declare the seminar open. Thank you.
school in University of Tokyo and learned law in 2006 to 2009. And when I was 50, so among a young student, I was also a law school student, and I learned law. And during the learning at the law school, I found that the theory of judgment in civil litigation called the ultimate fact theory taught in the law school is closely related with my work. The ultimate fact theory is a kind of decision making for judges. That is, in the real litigation, the judges cannot get whole sufficient evidence to make a decision. I mean that so sometimes, for example, in the contract problem, there might be no contract paper, but just the both parties said some telephone, and one party offered some request, and then the other party makes some approval. Then in legal situation, the contract is established, but because of the no paperwork in the litigation, it is not so clear that it is uncertain whether there are contract or not. In that case, deductively speaking, judge should say, I don't know, because of lack of evidence. But in litigation, you cannot do that. So how to make a reasonable decision under this kind of incomplete information is the main purpose of this ultimate fact theory. And non-monotonic reasoning is also aimed at making a reasonable decision in incomplete information. So the purpose is very similar. So I immediately found that I can implement this ultimate fact theory by my work. So I developed a programming language called Prolog-based legal reasoning support system based on the DS idea, and to aim at assisting law students and lawyers. And as a byproduct of the research, I passed the by exam in Japan in 2017. So after 1 year training, actually I can be a lawyer. So my current ambition is that after retirement, I will be a lawyer to use this project to make a lot of money. Anyway, so I would like to go for to talk about the current trend of AI applications to legal domain. So currently there are several commercial products related to the law domain using AI technology, and there are some usage of AI technique in the court. So I will discuss about 7 applications. Actually, the former 5 applications are related to civil litigation, and the other one is a criminal one. And actually, the 5 are successful one, and the 2 are something related to the dark side of AI application. So firstly, I would like to talk about e-discovery support in United States. In United States, there is an important process of fact-finding called e-discovery. And the original form is called discovery, and the discovery is used for the fact-finding phase, where if judge asks the party, either party, to give some evidence about some issue, then either party must provide the evidence related with that topic, with that issue. Otherwise, the heavy penalty will be imposed. So it is important to follow this discovery order from the judge. And e-discovery is extended to the electronic stored information. So before that, it is just a concrete thing, like just the existing one. But e-discovery is concerned with electronic stored information like Word file or some emails. And so the problem is that this kind of electronic stored information is enormous. So it's very difficult to find out the related evidence. For example, in this report says that there is a civil lawsuit brought by Clinton administration against tobacco company in 1999. And the Clinton administration claims that the companies hide the influence of health of tobacco and sell tobacco for many years. And during litigation, actually, tobacco company made a counter argument that it is a U.S. government to encourage tobacco company to sell the tobacco. And the judge asked the Clinton administration whether there is such a kind of evidence to encourage the tobacco selling. And in U.S., all the emails which governors, the officers used, have been stored. And 32 million Clinton era email records held by National Archives are investigated. And 25 people made information retrieval task for 6 months to give 80,000 relevant emails to Philip Morris et al. And so at that time, there is no such deep learning or other sophisticated AI technique. The human must make keyword search. So example of the keyword retrieval command is like this. It's very complicated. Basically, if there is master set argument or MSA exists and there is not medical savings and so on, so that is very, very complicated. But it takes much time to get this kind of very complicated retrieval command. But nowadays, there is some kind of support from the company called Ubiq or now called Frontier, has been providing support for e-discovery since 2009, so that this kind of command is automatically derived. And also, moreover, the international competition of e-discovery called Legal Track shows that using machine learning, AI provides better retrieval commands than human. So basically, this area of finding e-discovery is very successful application by deep learning. Another one is relevant documentary retrieval. And the company called Loss Intelligence developed document retrieval system using IBM Watson program to replace legal assistance by computer program. IBM Watson program is, maybe you know, but it is a program which wins a championship in the US quiz show called Jeopardy. And this program fight with champions, human champions in that quiz, and this program won the quiz, the championship. And so IBM would like to apply this to the real domain. So first domain is medical domain, and in medical domain there is a successful story that IBM Watson program can find out some cure about a specific patient, which has never been found by other doctors. So that IBM Watson program saves at least one life. And so Loss Intelligence company would like to apply this IBM Watson program to law domain. And actually, Loss made a contract with the Baker and Hostetler, which is a large law firm in US in 2016, and they use this program. and it saves the bacon and hostetler from a lot of time and money. And basically that this IBM loss program makes information retrieval given a case description. And if usually it is done by human paralegals, and but actually loss program is retrieves much better results than human paralegals, and therefore this kind of human paralegal has been fired now. Another one is checking contracts. The company Logix provides a system which reviews articles in contract documents and points out problematic articles. And so this blog of Logix says that they compete with lawyers about non-disclosure agreements review, and the system gives 94% accuracy of problematic article detection, whereas 20 lawyers' average of correctness is only 80-60%. And so basically that non-disclosure agreement, there is a sentence of the agreement, and there is some problematic article, then the system find out that this might be a problem. And the lawyers also read this article and finding out this article is problem. And so the technique of using this non-disclosure agreement detection is maybe used anomaly detection in AI technique. That is, there are a lot of ordinary contract articles are stored, and then given some new contract, then they check whether there is some anomalous sentences compared with ordinary contract sentences. And so in that case, the system just use some kind of deep neural network to detect the dissimilarity between the article of new contract and the article in the stored data. The problem is actually that they just say that it is problem, but what is the problem of that article is not said, but just say that it might be problem. Another one is patent troll detection. Lex Machina is the developer of this patent troll detection. And the patent troll company is enforces patent rights against the accused infringes far beyond the patent's actual value, and they are very bad guys. And so if some company is sued by this patent troll company, it is very difficult to win, so they have to be prepared for that. And the Lex Machina program gives 85% accuracy to find patent troll, and it may be used for a private company to prepare for fighting with such patent trolls. I mean, given all the patent litigation, the Lex Machina program find out this particular litigation is done by patent troll, and the accuracy is 85%. Another one is predicting financial ombudsman detection. The company called Case Crunch, which is a spin-off from the Cambridge University, made a program to predict whether the financial ombudsman would allow a claim. Financial ombudsman is a kind of organization which allows a claim for some problem in the contract, a purchase contract. And so there is some problem about the product, and then considering some contract of that product, and the financial ombudsman allow if the ombudsman allows the claim, then the reimbursement will be made. And the competition was made among the humans and AI, and given the basic facts of hundreds of payment protection insurance miscellaneous cases, and asked to predict whether the financial ombudsman would allow a claim. And they submitted 775 predictions, and the company won hands down with Case Cruncher getting an accuracy rate of 86.6%, whereas compared with 66.3% for, I think, the 100 lawyers. This is average for the 100 lawyers. So in this example, it is also AI is very efficient about finding out the prediction. So these are the all very good results, and also these applications are basically used in the real domain. But there are some dark side of AI usage. So in this system called COMPASS, Correctional Offender Management Profiling for Alternative Sanctions, is used from 1998. So actually it's not an AI program, but more related to statistical program. But deep learning is also statistical, so in a sense that is some kind of common property. And the COMPASS system predicts defendant's possibility of committing crime again, and is used for sentencing decision. And the judge somehow use this system to decide the sentences. But some people actually claimed that this COMPASS system might use racial prejudice. I mean that usually black people's committing crime is higher than the white people. So in that case, statistically speaking, if the black people in the court, then the COMPASS system might tend to say that he or she will commit crime again. But it's not a legal discussion, but more related to prejudice. So, but actually that the company which developed COMPASS system denied that they don't use such a kind of racial information. But some people again claim that they might use address of the criminal, and if the address is related with the slum district, then the crime rate is very high. So that means only the fact that the criminal lives in the slum district, the prediction rate becomes higher. It is not also a legal explanation. So there are a lot of such a kind of prejudice might be introduced in this kind of statistical system. I think that it is the same in the deep neural network system, so that the deep neural system just reflects the human's behavior or some tendency of data. So if human have a prejudice, then the deep neural network precisely reflect this prejudice. That is very dangerous. At least in legal domain, we need some, we need a correct legal explanation or reasoning without any prejudice. But if you use deep neural network in law, then there might be a danger of introducing such a kind of prejudice. So we have to be very careful about this. And also recently, Compass is no better at predicting an individual risk of recidivism than random volunteers. So that means that the usual person can do the same prediction by Compass. So that means that there are no way of using this kind of Compass system actually. Another criticism about the AI usage to criminal thing is that the usage of Bayesian network in criminal court. Bayesian network is also a kind of a statistical reasoning system, and but use of likelihood ratios in court to report on the evidential value of single forensic pieces of evidence is quite common, but it's very difficult. I mean that you need some kind of knowledge about the independence of multiple evidence. If this understanding of independence is wrong, then the whole result will be wrong. So the paper analyzes that in one case using Bayesian network, even seemingly expert on Bayesian network, he is not a forensic researcher, but a climate physicist. So he is an expert on Bayesian network, but he doesn't know anything about forensics or evidential reasoning in criminal law, so made a mistake of evidential reasoning. So even if we use this kind of technique, if we miss some assumptions, basic assumptions, how it works, it leads to the very wrong decision. So to summary, the works in civil litigation are based on a shallow technique of natural language processing, such as putting a larger weight to important keyword in information retrieval. Basically, deep neural network changing some, for example, word to vec is changing word into a vector space, which is somehow reflects the importance of the keyword in some domain of documents. And so it is nothing related with the meaning of the sentences. And also it's not, it is based on the similarity-based reasoning. Therefore, that if the logical reasoning is not so well manipulated by deep learning. I mean that if I say that this is a pen and this is not a pen, then the difference of the sentence is just one word not. And since deep neural network system doesn't know the semantics of not, the deep neural network thinks that these two sentences very similar. But logically speaking, its meaning is opposite. And this kind of logical reasoning is really difficult in deep neural network. So that part is some kind of problem related to deep neural network. And the main problem is explanation. So as I've said that in the contract checking, the system can say that it is problematic, some article is problematic, but there is no explanation. And also in Compass system, they just show that percentage of committing crime again, percentage of possibility of committing crime again, but no explanation why this guy has a high probability of committing crime again. And so in the ultimate form of deep neural network, if the judge is replaced by deep neural network, the current deep neural network then the network just says that you are guilty. And maybe the successful rate is very high, but there is no explanation. If the people accept that deep neural network decision without any explanation, then might would be okay, but usually people need some explanation. If you are sentenced to death, that's all. Then people says why, and in deep neural network doesn't produce such kind of understandable explanation. That is really very important problem and difficult problem. So nowadays, AI researchers, some of the researchers working on the explainable AI. So AI gives some explanation. Even in the deep neural network researchers working on this, but the problem in legal domain is that if this compass system, by analyzing compass system, maybe they produce some explanation, but the explanation is just not legal explanation, but just explanation by prejudice. As I said, that since he is living in the slum district, his possibility of committing crime again is very high. This kind of explanation might be arising by the deep neural network, but it's not correct in legal sense. So I think that there are two problems. That the first is that the statistical learning system should provide explanation, but this explanation the second problem is that this explanation might not be appropriate, especially in legal domain. So we need some other layers to give legal explanation. And so to generate explanation, we need to reason about much deeper knowledge about legal reasoning. And ProReg, which is our work, is one of such solutions. So I think that nowadays the cognition part is really can be implemented in deep neural network very successfully. But if we would like to go beyond using such a kind of reasoning, then the old-fashioned reasoning mechanism like logic is very important. So I hope that in 10 years, logical reasoning might be revived again. So so before going into my very technical details, I can accept any questions about this AI technique. Do you have any questions? Any questions is fine. AI in general. Okay. All right. Then I'll take questions after my talk finished. Okay. So I would like to talk about our main activity called jurisdiction informatics. Ultimate purpose of the research, of this research, is applying IT or AI technique to legal domain to establish new research area I call jurisdiction informatics. Actually, AI and law area started in 1960s. It's very early research area, but from now on, they too much emphasize on symbolic AI technique, like logic, and they didn't pay attention to the deep learning. That is actually not so good strategy, because deep learning is also useful for some part of the legal processing, like which I showed in the previous slides. And so my group submitted some legal document analysis by deep learning to the main AI conference, but it was rejected because they said that deep neural network is not related to legal reasoning and so on. So I started another workshop, and we accept this kind of new technology. So we would like to extend the scope of research between informatics and law, such as legal tech in general, by putting a new name for this research. So that is AI and law research already exists. So we would like to make our research different from the traditional one. So I call this research jurisdiction informatics. And I would like to simulate the success of bioinformatics. You know, bioinformatics is a kind of a combination of IT or AI technique with biology. And it is very successful, especially for DNA sequence analysis and so on. So I would like to make the same impact to the law domain. So I put juris is law and informatics is informatics. So I would like to I name our research juris informatics. And actually, we are now extend our scope not only for the technical thing, but also legal or ethical responsibility of AI. Nowadays, automatic driving car made an accident in real situation, and then there is some discussion about who is responsible for this accident. The producer of manufacturer of car, or the driver, or data provider for the automatic driving car. There are a lot of complicated issues in AI and of AI technique in their domain, like legal or ethical thing. So we also now accept the paper on this kind of responsibility, on this kind of issue. And I have been steering committee member of workshop on jurisprudence since 2007, and we will have 14th jurisdiction in November 2020 in Tokyo, in Yokohama, in Japan. So if you are interested in, you can submit a paper. Also, we set up a competition on legal information extraction and entitlement called COLI on this domain since 2014 with these people. And we have so far I think we have, we just held the COLI 2019 at ICAO 2019, and we will have COLI 2020 correlated with jurisdiction 2020. And I would like to briefly explain about the COLI task. So the purpose is to make a diverse research of solving methods of legal information processing, because there are not so many people working on this kind of thing. So I would like to extend our community. And from 2014 to 2017, 2 tasks related with Japanese bar exams are given. And since 2019, we also have a task related to Canadian cases. And for task 1 and task 2, we use a database of Federal Court of Canada case law decisions provided Compass Law. And task 1 is given a new case queue, extract some relevant cases for the decision of queue from the 200 randomly chosen precedent cases. And task 2 is give a new case queue and appropriate fragment of X extracted from it. So in one case, there are a lot of decisions, and we choose one decision and supporting case R, and identify the paragraph from R that enters this decision. Task 3 and Task 4 is related to Japanese legal bar exam, but the legal relevant data sets have been translated from Japanese to English, so that it is international competition. And we use yes/no questions derived from this legal bar exam. And Task 3 is given a question queue and the entire civil court articles. We retrieve a relevant set of S1 to Sn in civil court article, which is used for the entertainment task. And Task 4 is given a question queue and the relevant article S1 to Sn. We determine if the relevant articles enter doesn't enter the queue. And the current status is like this, so that if a measure of the task 1 is 55 at 0.57, task 2 is 0.70, and task 3 is F2 score is 0.45, and task 4 is 0.68. I think that the task 2 is somehow very good result, but still these tasks should be explored. So I would like to ask to explain about the other activities in informatics. The first one is collaborating with Marina DeVos and Julian Page from University of Bath on conflict detection of legal rules and conflict resolution based on inductive logic programming applying to GDPR compliance. And I have some slide here. So this is development of legal compliance mechanism for AI. And so the background is that the need is to solve the problem related with entrance of AI into human society. So there are a lot of emergence of legal problems produced by AI. And currently, if something wrong happens, then some litigation is made and some compensation is made. But it's somehow it might be too late. So we would like to avoid these legal problems in beforehand. That means we would like to somehow embed the compliance mechanism into AI so that the AI tries not to violate any legal or ethical issues. And there is a lot of seeds in technical seeds which we have already done. And we have been developing ProReg and representing Japanese civil code and Supreme Court decision. And also we can apply ProReg to various rule-based laws since it uses general rules and exceptions. And we can introduce contradiction finding and contradiction resolution into ProReg. The contradiction finding and the contradiction resolution is somehow related with logic. And the ProReg is based on logic programming, so we can use some technique from this research domain. And also, we have already done contradiction finding and contradiction resolution by collaboration with these people. And so they use INSTAL, Institute Representation Language, developed in Bath University, and to detect contradiction of a different legislation. So INSTAL is different from ProReg, but it is quite similar because we have a common background in logic. And also we have contradiction resolution when upper legislation is contradiction with lower legislation. For example, EU law and domestic law. Then if domestic law is contradicted with EU law, then the European Union law should be respected, so that domestic law should be changed. And in that case, we have to find out what is the source of the contradiction in domestic law, and we should change the domestic law to comply with EU law. such kind of thing exists. So we would like to develop a framework how to represent semi-autonomous legal rules written in ProReg. And we write legal rules and specification of AI behavior in ProReg. And then we develop the specific algorithm for contradiction finding between legal rules and AI behavior using abductive logic programming. And also we develop the scaling up algorithm for contradiction resolution by modifying AI behavior using inductive logic programming. And but this is just a starting project, so this is just, we hope we would like to develop this kind of algorithm. And as a concrete test bed, we take GDPR, which is General Data Protection Regulation, which was became valid last year in Europe. And it is very, very important private data related law. And for example, the Google violates this GDPR, and they have to pay a fine of more than $1 million. I think more than that. So there is a lot of problem about this. So if the very small company violates GDPR, and if the EU find out that kind of violation, then the company must pay a lot of fine. And so it's very important to detect whether the company's policy follows from GDPR. So it's now a very important problem in Europe. Okay, so I return to the previous one. And I'll talk about the product later. And this is, and using developing, and we develop a debugging tool of product used for legal debugging with my student. So I would like to show you some example here. So legal debugging tries to formalize how the court solves unexpected consequence which the literal interpretation of the law may lead to. And legal debugging consists of two algorithms, the culprit detection and the culprit resolution. It is somehow similar to the contradiction detection and contradiction resolution in the previous work. But we use some kind of interactive algorithm here. So for example, in the example case, the plaintiff made a lease contract for his room between him and the defendant. When the defendant went away for a while, he let his son use the room. As the plaintiff found out, so he claims the contract was cancelled. And according to the Japanese Civil Code Article 612, phase 1, a lessee may not assign the lessee's rights to or subletting without obtaining the approval of the lessor. So that means the borrower should have the approval from the lender. And if it is violated, then the phase 2 says that the lessor may cancel the contract. So that means if the violation of subleasing without approval, then the lessor can cancel the contract. So from this rule, actually the cancellation is valid in this very special case. But it seems that the result seems too harsh, and so that actually that the Supreme Court decided to change the interpretation of phase 2, or we add some exception to the phase 2. Phase 2 is not applicable in exceptional situation where the sublease doesn't harm the confidence between the lessee and the lessor, and therefore the lessor cannot cancel the contract unless they prove the lessee's destructing of confidence. And the court finds the cause of unexpected consequences and introduces extra facts for explaining exceptional cases. So basically, if there is no abuse of confidence, then the phrase 2 cannot apply. So it is not written in Article 612, but the Supreme Court can somehow revise this Article 612. So the problem is how to find out that which article is a source of contradiction or a problem, and how to change it. So this work is related with these two problems. Okay, I change. And also, we are developing a method of legal information retrieval based on viewpoint inquest project supported by JST. And actually, this work is related to task 2, task 1 in the CORI, which is I showed before. CORI task is given news case queue, extract some relevant cases. And we use a deep neural network for this application. And our group won task 1 of CORI competition 2018-2019 by summarization technique using deep learning. And in this task, we don't use the whole case, but we firstly summarize this case into summary, and we compare the summaries whether there is a relevant or not. There is a relevancy or not. So the case is the length of case is very, very, very long. So if you use these cases, then there are a lot of noises. So by summarizing the case into the very important sentences, then we can extract the more very useful information for retrieval from the summarization. And we use deep learning for the summarization task. We also develop a total support system of judgment, including fact-finding, subsumption, and judgment reasoning. Actually, the action in litigation consists of 3 phases, that is fact-finding, subsumption, and judgment phase. And the project is actually supporting this judgment phase, so that I would like to extend other phases, fact-finding, subsumption phase. So we to introduce some other mechanism now. It's just also started. Also, formalizing choice of laws in private international law conflicts through international private affairs, such as international marriage, divorce, and inheritance. For example, not here, sorry. For example, this is a problem in private international law. Given an international, So usually that if the Taro and John have the same nationality and in the same native country, there is no problem. If Taro is a descendant of John, then he's heir. But it becomes very complicated if Taro's parents do not have the same nationality, and also with Taro as well. So this matter cannot be answered only considering the legislation of one country, but requires deciding the legal system according to which the court has to decide. For example, John is an American and got married with some women, some Japanese women in France, and have a baby in Brazil, for example. In that case, there are a lot of countries involved. So this international affair cannot be solved in one country's legal rules, but we have to apply the various countries' rules. So how to decide which rules should be used for a particular problem? For example, the marriage of the John and the other woman is valid in France if it is married, but is it really valid in Japan or in Brazil? That is not decided by the French law. So in that case, how to solve this kind of thing is related to the private international law, and we would like to formalize this kind of thing in logic. That is another activity. Okay. So I would like to talk about a specific research theme called prologue-based legal reasoning system. And okay, so overview of prologue system is the prologue system is a supporting tool for judges in judgment phase, and it is based on the Japanese presupposed ultimate facts theory and logic programming. And we have implemented more than 2,500 rules in civil law and Supreme Court cases by law school students from University of Tokyo. And so firstly, I would like to talk about reasoning steps in civil court litigation. And civil court litigation consists of 3 steps, and the actual prologue attacks or supports judgment phase, but I would like to be complete, I would like to talk about another phase as well. So in fact-finding phase, a judge decides the truth value of facts in the considered case. Facts should contribute to judgment using evidence. And evidence itself is also fact, so we need to decide the truth value of evidence. And so, for example, suppose a judge would like to decide whether there was an agreement about purchase of goods or not. And then if a plaintiff gave some basic facts, such as email exchanges, which can derive the fact of agreement, a judge will take into account of this basic fact. But actually that this email exchange might be false. Just the plaintiff might made up this kind of email exchanges. So that kind of genuinity of email exchanges also should be considered in this fact-finding phase. So it becomes very complicated, actually. And then the next phase is subsumption phase. A judge makes correspondence between specific facts and legal concepts. So, for example, suppose the judge decides the truth value of agreement for the purchase of goods is true, then this agreement corresponds with establishment of contract in a legal term. So the truth value of establishment of contract is true. So this is legal term, and the agreement is the event in the real life. So that is real world and legal world. And in the legal world, we use legal rules, applying legal rules, and we decide whether there is a right or obligation about some specific issues. But to decide it, we need to make a correspondence of the event in the real life, and some legal concept in the legal world. That is called subsumption phase. In this particular example, it is very easy, but there is a lot of abstract legal terms in the legal world. Like, for example, in tort cases, there is concept error. And if the error happens, then some compensation should be made. But there is a lot of errors in the real life. So given some sequence of events, we need to find out which is real fact related to the error. But that kind of activity is very difficult. So now I would like to say about judgment phase supported by Prof. So according to the truth value, a judge decides which legal rights or obligation exists. However, as I've said in the first slide, the truth value is 3 values, so some judgment could become undefined. And in a deductive logic, and in this case, a judge cannot make a deductively correct decision. But in the litigation, a judge cannot allow to give a judgment of I don't know, so and is forced to make a decision. So to solve this undefined situation, the Japanese principle of the ultimate fact theory is invented by judges. And so basically that the idea of the Japanese principles of ultimate fact theory, I say JAF theory now. JAF theory is that if the conditions, truth value of conditions are decided, then the conclusion can be made. I mean that if the conditions are all true, then the conclusion is derived by logical reasoning. If some of the condition is false, then you cannot derive the conclusion. So that is the logical way. But in litigation, some part of the condition is undefined. So to solve this one, so in JAF theory, they define the default truth value in advance. So if the condition is found to be true or false, we just use that value. But if it is undefined, then we use the advancedly defined default value is used. Then all the conditions have the truth value, so that the conclusion can be made. So that the main part of the JAF theory is how to make a default value for each conditions in civil litigation. And that kind of default reasoning, it is some kind of reasoning called default reasoning, is actually what I have been studied for 30 years. So I immediately find out that I can implement this idea into logic programming. So I developed a Prof. And the Prof system consists of rule-based and fact-based. Prof rule-based consists of the following expression. That is, first one is called rule or general rule, which is of the form of this one. H is the conclusion, and left arrow, and then the condition. This means that if the conditions B1 to Bn are true, then conclusion is true in general. In general means not always. There is an exception. And the exception, we have another construct in the rule base that is called exception. Exception is a form of exception HE. H is this conclusion, and E is another conclusion. If the E is true, even if B1 to Bn are true, H is not true. So if E happens, then it is an exception of this rule, so that H cannot be derived. So this is the prolonged rule base, and the prolonged fact base consists of the truth value of basic facts. So it describes a case, the particular case. So the working example is similar to the previous legal debunking example. A plaintiff made a lease contract for his house between him and the defendant, and the defendant let his sister use a room for a piano lesson. The plaintiff claims the contract was ended by his cancellation of the contract because of the defendant's sublease without permission. Then in turn, the defendant attacks the plaintiff's claim that his subleasing a room to her does not cause any destruction of confidence with the plaintiff because the time of use per day was very short. And then in turn, the plaintiff attacks the defendant's counter-argument that the defendant abused the confidence with the plaintiff because there are neighbors' complaints about the noise from piano lessons during subleasing. And as I've said, it is the article called Civil Code Article 612. And also we have a Supreme Court case rule at the phase 2 is not applicable in exceptional situation where the sublease doesn't harm the confidence between lessee and lessor. And this is a real example, real prolonged rule base. So cancellation due to sublease, and there is some the argument here. This means there is some lender and borrower, and there is cancellation at the time T, cancel. So conclusion is called if these conditions, 1, 2, 3, 4, 5, 6 conditions are satisfied in general. So there is agreement of risk contract between lender and borrower, and lender hand over the object into the borrower, and then there is an agreement of borrower and explorer. So this is sublease contract. And then the borrower hand over the object into explorer and explorer make use of this thing, and the lender manifest the cancellation to borrower. Then in general, cancellation due to sublease is true. However, we have another exception. So cancellation due to sublease is has an exception if there is approval of sublease, and approval of sublease has some rules that the date of approval sublease should be before the day of the accept. And there is another exception by the Supreme Court case rule, so that the exception is that if no abuse of confidence exists, then cancellation due to sublease cannot be made. And the prolonged fact base is like this. So the agreement of risk contract is done between plaintiff and defendant of this real estate, and 10,000 euro per month from the contract date is 2004, the April 1st, and term is 5 years and so on. So this is stored in the fact base, and applying the rules of these things, we can derive the conclusion. So I'll show you some demonstration here. So this part is a rule base. So this is exactly the same as which I showed in the slide. And there is a fact here, and we can compare this already. So I show some example here. So this is a kind of a dynamic representation of reasoning. This is too small, so I prepare for the larger one. So this part is a conclusion. So whether plaintiff and defendant can cancel the contract or not. And the bottom part of the box gives the result. This circle means yes or true, that the conclusion is true. It is because in firstly, we have to check that all the condition is true. So from the fact base, we just instantiate some variables in these rules and find out that there is a corresponding fact. So there is 1, 2, 3, 4 conditions here, and they are all true. But as I've said, there is an exception. So we have to check the exception here. So this dotted line is a checking of the exception. So first one is approvable sublease. Are there any approvable sublease beforehand? But this X means that there is no such a kind of approvable sublease. Therefore, this exception is denied. How about non-abuse of confidence? So in this case, fact of non-abuse of confidence was displayed by defendant, so there is short-term usage. However, there is an exception of exception, that is the abuse of confidence. There is a complaint about subleases usage. Therefore, exception of exception is true. Therefore, exception is false. And as a whole, all the exceptions are false. Therefore, original conclusion is kept. Therefore, the cancellation due to sublease is made. So this kind of general rules and checking the exception, and if the exception is true, then we have to check about the exception and so on. That kind of way of reasoning is exactly lawyers are doing. Therefore, this diagram fits the lawyer's reasoning. Okay. So current status are, as I've said, that around 2,500 rules of civil code and civil court case rules are implemented. And we check the validity of these rules by solving yes/no questions of Japanese bar exam 2008-2017. So this rule set is quite correct. And currently we don't have any industrial applications, but I hope that there is a possible application like education of law school students and also validity check of lawyers' arguments. However, there are a lot of limitations. Firstly, as I've said, it is only for the support the judgment phase, and we don't support the fact-finding phase and substance phase. So we need some other mechanism for that. Besides that, a user must know the predicate name in ProReg and the meaning of arguments in the predicate and the instantiate arguments according to the case. So ordinary people is difficult to use ProReg. So we are working on information extraction from natural language sentences which describe the case. And ProReg doesn't support fact-finding things and also substance phase. So this part is problematic. And the ProReg doesn't give information which condition is in the primary rule and which conditions is in the exception. So actually that the main activity of JAF theory is to find out the default value of the conditions. It is in ProReg, it is corresponding with which condition is the condition in general rules and which condition is the exception. That part is not derived from automatically, but we need help. We need help from human. Also, ProReg doesn't decide the judgment is valid in terms of the current society status. So human must decide the judgment is valid. But if human says that the judgment is invalid, then using a legal debugging mechanism, we can identify the which rule is problematic, and also we can suggest that how this contradictory rule can be changed. Okay, I conclude my talk. So I found that there are many opportunities to apply informatics AI techniques to legal reasoning, besides above work, which have not been explored. And also, importantly, I think that the current deep neural network doesn't solve the most important problem in legal reasoning, especially for legal explanation. So I hope that some people might find the old symbolic AI important and to support our research. And jurism informatics becomes very important in order to control over rapid society change due to IT and AI, such as blockchain, smart contract, and automatic driving cars. So by controlling, to control these activities, human is now working on making rules, but maybe it is too late, because if we make a rule to control over the current technology, then the current technology becomes outdated and new technologies are provided. So then we need to control over that one, but it's too late, and so on. So we need to have some kind of support from IT and AI to control over blockchain, such a kind of new technology as blockchain, smart contract, and so on. So I think that jurism informatics are really important in future. Okay, thank you very much. So I could accept any questions, not besides this work, but AI in general. Sure.
Can I ask a question? How much percentage that code has been used in real case compared to like every case in the same track of the case?
I'm sorry that.
Okay. How much percentage that code has been used if compared to like some cases?
Currently there is no industrial application, but so it is just a research phase. So I'm trying to sell the product, but currently there is no industrial usage. Yes. It's a little bit. No. I'm trying to sell, but I'm trying to sell, but currently in Japan, I think that they are not so very interested in AI because there are a lot of problems in Japanese code. So basically, that Japanese code is based on papers. So electronic data is very small. So we cannot use deep learning thing because there are no electrical data, and therefore that is a real problem. So in United States or Canada, all the cases are electronically public, so that we can use deep learning technique for natural language processing. But in Japan, the electrical data is very small, so human must make a lot of effort to make data, and so that law firm don't like to invest these things currently. Really? Yeah, thank you. I think in Thai language is very difficult to analyze. So if you have a very good application in legal document, then it would be very useful, I think. Compared to the other languages, Thai language is very difficult to be processed. For example, you don't have any period, so that how to segment sentence is difficult compared to the English and so on. And then if you provide some legal Thai language processing, then it would be very impact, I think. Okay, thank you. Yes.
I wonder why to use AI technical for give a legal judgment. Legal listening. Why not human?
Why not human? What?
Why we have to use AI technical
Yeah.
to give a legal listening?
Yes.
Why not human?
You mean that ordinary human uses legal reasoning?
Why we have to use AI application?
Mhm. Well, I mean that so currently this system is used for judges and not for ordinary people. But so ordinary people, for ordinary people, I need natural language processing so that ordinary people just describe the case in ordinary language. And then the natural language processing program will extract some logical fact from these sentences. Then we can do it. The problem of how to extract this logical data from the natural language sentence is very, very difficult. Therefore, currently, ordinary people cannot use this product, I'm afraid. Of course, if our application, the application is very small area like just traffic accident, then we can use some kind of a table-based query, so that who is the driver and what is the situation and what is the car type and so on. So that kind of table-based QA can be possible, then we can use ProReg. But currently, we don't work on such a kind of specific domain. So currently, it's rather difficult. Okay.
Can I add?
Well, it contains a lot of noise.
I add my discussion. I think AI that like Professor Satoh or some people try to do. I think they want to assist, right, judge or lawyer to make decision, to make better decision. I think that will help not replace human. Okay.
Right. About the replacement, I think that if the case is very routine work, then I think that human is very boring. So that such a kind of very routine work decision, then the problem can be replaced by judge, can replace judge. But it is very simple one. But if it is complicated, then the AI is just assistant of judges. It's very difficult to replace it. Okay. Okay. Okay, thank you very much. Thank you.
on behalf of the Faculty of Engineering, I would like to thank you, Professor Satoh, to give knowledge about AI and prologue for us. Thank you very much.